Moving further to our next session on the changes in merger and acquisition, we are pleased to welcome Sandeep Jhunjhunwala to provide his expertise analysis. Mr. Jhunjhunwala leads the Corporate and Merger and Acquisition Tax Division and Emerging Law Practice at Nangia Andersen India, bringing over 16 years of international tax and strategic advisory. We are pleased to welcome Sandeep Jhunjhunwala. I think, let me check once. Yeah, it's fine now. Let's start it again. Mr. Jhunjhunwala leads the Corporate and Merger and Acquisition Tax Division and Emerging Law Practice at Nangia Andersen India, bringing over 16 years of international tax and strategic advisory experience from top Big Four firms. He oversees key relationships with global partners, particularly in the USA, UK, and Ireland, and is integral to Andersen's technology, real estate, and employment law group. Mr. Jhunjhunwala advises on corporate international tax, cross-border structuring, and controversy management, often working closely with the regulators to shape policy. A frequent speaker, columnist, and broadcaster, he has served as an honorary member and authored Decoding RERA, a guide on real estate. Welcome, sir. How are you?
Hey Divya, hi. Thank you for the introduction. I hope I'm audible.
Yes, sir, you're audible.
Okay. Good evening to all the participants. I'll just share my screen as we speak. Divya, can you please confirm if this is visible?
Not yes, sir, it is visible now.
Sure. Thank you.
Okay, sir.
So good evening, all participants. I think in this segment of the Taxmann Marathon Budget 25 related discussion, we are going to talk a little bit about the policy announcement that was made in respect of fast track mergers and a key amendment, though it's on the detrimental side for M&A related activities. So, and a third one, which is in terms of a clarification that has come from the government, to clarify what position should be taken as far as characterization of income is concerned for transfer of any securities by AIF. So these are the broad three topics that we are going to discuss through this M&A segment of the budget marathon. Now, coming to the first one, as I said, this is more of a policy announcement, and Honorable Finance Minister, as a part of her budget speech, I'll just read that out for the benefit of the audience here. She said that the requirements and procedures for speedy disposal of company mergers will be rationalized. The scope for fast-track mergers will also be widened and the process made simpler. So this comes as para number 101 in the budget speech of the budget 2025 by the Honorable Finance Minister. So it's more of a policy announcement. There is, it's more directional in nature. There is nothing tangible at this point in time. But let me take a moment here to, apprise the audience about what kind of pendency are we looking at the NCLT level when it comes to approval of various matters, which goes through NCLT for multiple applications. So, NCLT technically gets matters from two different statutes as I speak. The first is the Companies Act, where Section 230 to 232 dealing with matters related to, say, for instance, compromises and arrangements, corporate debt restructuring, capital reduction. Those kind of applications are under Section 230 to Section 232 of the Companies Act. And then we have Section 233 of the Companies Act, which deals with fast-track mergers. So under the Companies Act, these are the two streams, and definitely a larger, influx of the matters as far as approval is concerned goes to NCLT from the IBC-related cases. So if we look at the published statistics, what we see is, what is depicted as the chart on the table is the kind of pendencies that we have at the tribunal level. These are based on the applications received and considered by the regional directors. If we look over a period of time, both in this segment, which deals with 230 to 232, as well as in Section 233, what we find is that technically the opening the opening burden of the cases doesn't get sorted. So this 490 is the opening year, 841 represents the matters received during the year, 819 is the disposal, and then 512 is the applications pending at the end of the year, which technically remains the same across, right? Even in 233, if we look at the fast track cases, and the last year as an example, for instance, for the purpose of this discussion, we had 173 as the opening, pending application at the beginning of the year. Almost 450 applications were taken up during the year. Disposal is around 508, and technically we are left with almost the same set of application as pending at the end of the year. Also, an important fact here is that if you look at the NCLT caseload based on the data published by the NCLT, interestingly, it says that 95% of the cases are disposed. Now, I'm not too sure because what we have been seeing is that at least from a disposal standpoint, NCLTs are taking nowhere less than 1 year to 18 months. So 12 to 18 months is the minimum timeline that we are seeing at NCLT level for matters to get disposed as far as Companies Act applications are concerned, whether it be under 230 or 233. But the NCLT website tends to probably give a picture where it says that starting from 2016 until October of 2024, there were close to around 18,336 cases which were taken up, and around 17,324 cases which were disposed, which means that the cases pending are only close to 1,000, giving it almost a 95% strike rate for the disposal of the matters. As I said, maybe the statistics is not quite clear to me here, but there's a definite need for simplification and the rationalization of the overall merger and the reorganization process, a part which the FM also acknowledged as a part of a budget speech this year. So all this will bring is maybe enhanced efficiency, attracting investments, ease of doing business, boosting the economic activity, etc. If at all the process is made a little more efficient. Now, talking about the fast track merger, currently under Section 233 of the Companies Act, a fast track merger is available only for limited segments. For instance, if it is about a merger of two or more small companies, a small company being defined as a company where the paid up capital doesn't exceed 4 crore and the turnover as per the immediately preceding financial year doesn't exceed 40 crore. So this is the threshold for a small company, which is defined under the Companies Act. The second avenue is when it is about a merger between a holding company and its wholly owned subsidiary. The third is about a merger between two or more startup companies. Startup companies is again, defined by the DPIIT. There's a notification that was issued in 2019 to define what are the startup companies. There are certain segment of companies, say for instance, if a company has any foreign asset or a liability, if it is a subsidiary of an overseas company, those categories of company are specifically excluded. And the fourth category is a merger between one or more startup companies with one or more small companies. So these are the only four broad segments which gets eligible for a fast track merger. Now, as I said, as a part of the FM speech, she mentioned that the scope for fast track merger will be widened and the process will be made a little more simpler. Now, we have been taking some steps, toward widening the scope of fast track merger. In September last year, there was an announcement to, make that process a little more simpler, where it was stated that NCLT approval will no longer be required for cross-border mergers, and it will work only with the RD approval along with RBI. So NCLT approval will was no longer made as a requirement for cross-border merger, in the case of a merger of a foreign holding company with a wholly owned subsidiary in India. Now, this obviously was, intended to promote the trend of reverse flipping of structure, the inbound flipping, which we had seen in some of the cases which I have tried to highlight on the slide, say in the case of Pepperfry, PhonePe, Grow, Zepto. These are all the cases where We are seeing companies which had actually set up outbound structures externalized in the past. They are now looking at flipping back, internalizing, and coming back to onshore in India. Now, definitely some steps are already being taken, and maybe post this budget speech or the budget announcement, the government may possibly look at widening up the scope. And I think it's important that we look at some of the recommendations that were made by the company law committee and some of the industry recommendations to ensure that the scope of the fast track merger is broadened a bit more. So what were the key recommendations? They first said that the merger of a holding company and any of its subsidiary, whether then it's a wholly owned subsidiary or otherwise, should be covered under fast track. The mirror demergers for listed companies should get covered under fast track. In fact, I mean, the last bullet point, which is the merger of two or more unlisted companies, the ask was that only listed company related mergers should go to NCLT for approvals. Other than that, if it is a case of merger of two or more unlisted companies, which are typically private limited entities, then it should not even be subject to NCLT approvals. Having said that, all of these are recommendations which have been made by the company law committee and from the industry at large, but we have to wait and see for more concrete discussions and maybe announcements by the government to show all these recommendations the light of the day. This slide talks a little bit about what are the existing challenges in the NCLT merger process. As I was trying to highlight at the beginning of this discussion, we only have 16 benches, including the principal bench of the NCLT. So technically, if you look at the per bench caseload, it's quite high. In fact, some of these benches are not even operational. So 16 benches are the one notified, and not all of them are operational. So technically, that also creates a block in terms of efficacy when it comes to dealing with this kind of matters. Obviously, most of the NCLT needs to be digitally improved when it comes to improvement in digital infrastructure. Setting up some of the standards, say for instance, some template-based submission schemes, orders, etc. I think those are the issues that definitely needs to look at. And again, as far as declogging the NCLT is also concerned, there were certain recommendations which were made in the past. Like for instance, today, if we have a company where the jurisdiction of both the entities which are undergoing merger needs to approach the NCLT in their respective jurisdictions. Now, a ask there could be was it should just go to the NCLT of the transferee jurisdiction and not add up to the case also for the transferee jurisdiction. There were also recommendations in terms of use of technology, use of certain procedures, standard templates, submissions, etc. The reduction in the consent thresholds, because at the end of the day, these are privately held companies. So the existing, the threshold of 90% possibly could have been reduced to say 45 to 75% of the value, or maybe a 50% of the shareholders representing 50% of the total value of the shares in the company. So all these recommendations have been made in the past, but we'll have to wait and see when it sees the light of the day. So this is on the first policy-related announcement related to merger of the companies, where the FM acknowledged that there is a need to make it a little more efficient, and we'll have to wait is finally given implementation. Now, coming to the most debated topic in terms of carry forward of losses in the cases of amalgamation, the change which was brought in Section 72A and Section 72AA of the IT Act. Let me just take you through a little bit of history of Section 72A first, and then we will deal about what are the amendments. Now, 72A typically deals with succession of business in the case of, say, a merger or amalgamation, where the loss of a predecessor entity is allowed to be carried forward and utilized by the successor entity. And this was introduced way back in 1977. So it's almost a 5-decade old provision. And what surprises me is that probably it took 5 decades for the regulators to ascertain that this is an area which possibly requires an amendment. In fact, 72A and 72AA are pari-materia sections. 72A applies to undertakings which have manufacturing setups, which owns a ship or a hotel, etc. Whereas 72AA applies to banking companies as well as government companies. Now, otherwise, the basic structure and the construct of both these sections are the same. They carry a specific anti-avoidance rule in the section itself, which says that the eligibility for carry forward of losses under section 72A is to be given only if there is a business continuity and there is a book value of the fixed asset which is continued to be carried over by the amalgamated company. So therefore, technically, 72A in itself carries a specific anti-avoidance clause. It also says that the company should probably be undertaking this amalgamation or merger only for genuine business purposes. There is also a rule 9C which is related to 72A, which has certain conditions additional to what is given under 72A, which includes that there's a requirement to reach a 50% installed capacity before 4 years of whatever was the capacity before 4 years before the amalgamation, and continue till the end of the 5th year with that at least 50% of the installed capacity. And there is also a requirement to file a Form 62, which is issued by the principal officer of the amalgamated company and verified by a chartered accountant. So therefore, a question comes up is, was this amendment really required to be put in place? Because all this while the government has been saying trust first and scrutinize later. But I really don't understand why this amendment was really brought into place. Now, if you look at the explanatory memorandum to this, which is very important for us to understand as to why this section, this amendment was brought in, it says that in order to bring clarity and parity with the provisions of Section 72 of the Act, it is proposed to amend Section 72 of the Act to provide that any loss forming a part of the accumulated loss of the predecessor entity. So technically, what they are trying to say is that this is brought to bring clarity and parity. And it also says that the proposed amendment is aimed to prevent the evergraining of the losses of the predecessor entity resulting from successive amalgamations. And we will talk about how this evergraining of losses happens. Now, in the example here, we have a company A where, say, for instance, the company A in assessment year 13-14 has incurred business losses and it is carrying it forward. Technically, as per the requirement of Section 72 of the Income Tax Act, it can be carried forward only for 8 successive assessment years. So we started with assessment year 13-14, can be carried forward as per Section 72 up till assessment year 21-22. Assume that the company A merged with company B in assessment year 19-20, right? So as per the current Section 72AA, there is a reset at this point in time, right? And therefore, the reset allows company B now to carry forward the losses of the predecessor entity. And the 8-year will be now counted from AY 1920. So from 1920, again, I'm allowed to carry forward the losses from 1920 up till 27-28. Now, assume that there is a second merger that happens between company B and company C. This reset again will happen here, and then I can again carry forward the losses here from here for the next 8 years. So technically what we are seeing is the losses which originated from company A here, which technically should have lapsed only in assessment year 21-22, is now allowed to be carried forward, indefinitely. Now, this could be a case where there could be a successive merger happening and the loss never lapses, right? So this is what the government felt was a problem statement. We also have a ruling in the case of Supreme Industries, which has blessed this position. They have in this ruling clearly said that there is a reset and there is a fresh lease of life given to the business losses. And, therefore, the losses never lapses in this kind of transactions. So therefore, the idea was to include an amendment in the finance bill, which they have done now. They have now said that the losses cannot be carried forward beyond what the original section, which is 72, permits them to do. They have now inserted a subsection 6B in the main section 72A. So as far as 72A is concerned, they have inserted subsection 6B. As far as 72AA, which deals deals with banking companies and government organizations, they have inserted this by way of a proviso. Now, what kind of structurings are covered by this amendment? Amalgamation, succession of a private company or an unlisted public company by LLP, and the succession of a firm or proprietary concern by a company. We spoke about the rationale. First is clarity and parity with section 72. Second is evergreening of losses has to be, prevented. But I mean, I really don't know why a 1977 introduced act, a section took so long for the government to decide that this kind of amendment is required. Another aspect is that there was a carve out for demerger, which was made in 72A in 1999 by introducing subsection 4. So in the case of a demerger, actually, that in the case of a demerger, the demerged entity doesn't get a fresh lease of 8 years, and it has to be carried forward and utilized only as per the basic construct of section 72, which is 8 years. But even at that point in time, it was not thought through. And now possibly government feels that maybe based on some of the transactions or the volume of transactions that may have been happening recently or of late, they felt that this restriction is required to be brought in by way of an amendment. So let's take the case of a merger. We have a company A. We are talking about assessment year 2021. Business loss can be carried forward for 8 years, which is 28-29, up till 28-29. We have a merger of company A happening with company B in assessment year 26-27. Now, technically, as I said, the losses of AY 2021 can be carried forward only till AY 28-29. I will not get a fresh reset of 8 years at this point in time. And therefore, the entire losses will lapse if not utilized by end of AY 28-29. Let's take a case of a successive merger. Company A, assessment year 15-16, losses can be carried forward for 8 years. So 15-16, we can carry forward to only 23-24. Let's assume that there was a merger of company A and company B in AY 21-22. I can actually carry it forward only till 23-24. So for some years, some of the losses can be carried forward because AY 21-22 is before 23-24. But as per the earlier provision, there should have been a reset here, which will not happen. And the losses can be carried forward now only up till AY 29-30. So therefore, this is what the business loss of company A for AY 15-16 can be carried forward only till 23-24. And company C will not be able to utilize the losses which are pertaining to the original predecessor, which is company A in this case. So therefore, one thought is that if merger of company B with company C had not been taken, then company B could have carried forward and utilized losses up to 29-30. As the merger of company A with companies B is affected prior to April 1-25, and therefore the current reset related restriction would not have applied in this case. So this is how my successive mergers will get impacted going forward. We have given an example by way of a tabulation. I'll help you decode how this table is. We are talking about 4 consecutive mergers happening. These are 4 successive mergers. This row talks about assessment years. We have first event, which is company A merging into company B. Then we have that company merging into company C. Then we have that company merging into company D, and the last merger is with company E. So merger 1 relates to merger of company A with company B. Merger 2 relates to this company merging with company C. Merger 3 relates to this company merging with company D. And merger 4 relates to the final merger, which is D into E. So this is how the interplay of all the numbers would be. These are the different assessment years which are listed out. Let's assume that the company A has been incurring losses to this extent, which is 20, 25, 15, 20, and 10. So therefore, on an overall basis, I have a cumulative business loss of 90. I have a company B which has, a loss of 20. And in the year of merger, I have a loss of 10. So this 100 comprises of 90 and a 10, which is a standalone merger of. So 90, which comes from here, and the 10 is the standalone loss of company B, right? And similarly, we have case where, company C also had, losses on its own, company D having losses on its own. The total pooled loss, if we look at it, is 310. Now, the question that arises is that after implementation of this new subsection 6B, which has been inserted in 72AA, is company E entitled to take this cumulative 310? Because this 310 is a number which is cumulative of all these past year losses of the predecessor entities. Now, the answer to this situation is here. The accumulated losses aggregating to 170 crore will lapse post-merger in AY 26-27. So this company A related loss will fully lapse. So this green is the 8 assessment years that we're talking about. We are in assessment year 26-27. I can go back 8 years, and therefore I'll have to stop here. So any losses which are beyond this will all lapse. And this is what the answer here is. Company A losses 90 crore will lapse, B's 65 crore will lapse, and company C's 15 crore will lapse. Loss of assessment year 18-19, which is 25 crores, could be set off against the income of 26-27. So this is the benefit that one gets only, for the year in which that, utilization has to be done. And the accumulated losses from 1920 onwards, which is a cumulative of 115, can be carried forward to 27, 28, and subsequent assessment years, subject to the 8-year limitation limit. So this is how this entire thing will, work out. So it just makes the entire problem a little more complicated for company E, because if section, subsection 6B was not there, then company E need not even look at all these breakdowns of losses assessment year wise, and for the predecessor companies, it could have easily just taken over this 310 completely and utilized it for 8 subsequent assessment years. So this is how maybe mergers, successive mergers going forward have to be dealt with, to see which are the losses that lapse and which are the losses which can actually be carried forward and utilized by virtue of section 72 of the Act. Another important aspect is here, it says the way the finance bill reads out, it says that this 6B will be applicable to amalgamation of business reorganization which is affected on or after 1st of April 2025. It uses the word affected. Now, the word affected is not defined. So therefore, one view is, will I look at the date of the order sanctioning the merger, or will I look at the appointed date, which is the date from which the order is effective? So technically, the view is, let's say, for instance, there's a company A where assessment year 2021, you have a business loss here. Loss can be carried forward up till 28-29. Now, view 1 is that if I look at the date of order sanctioning the merger, if the order date, say, for instance, is October 1, 2025, it falls into the next year. And therefore, as per view 1, the loss can be carried forward only up till 28-29, which is up till 8 year. The view 2 is, if I go by the appointed date, if I mean to say that the word affected would mean appointed date, then 6B itself doesn't apply. The new amendment doesn't even apply on this, because the appointed date is prior to the date on which this amendment has been made, and therefore loss can be carried forward for fresh 8 years, starting from the date of the appointed date. So technically here also in the case, there's a ruling in the case of Marshall Sons, and that ruling is from the Supreme Court. It's a 1997 ruling from the Supreme Court in the case of Marshall Sons and Company. They have clearly laid out as a part of the ruling that every scheme of amalgamation has to necessarily provide a date with effect from which the amalgamation shall take place. The scheme concerned herein doesn't provide the date. It is true that while sanctioning the scheme, it is open for the court to modify the said date and prescribe such date of amalgamation or transfer as it thinks appropriate in the facts and circumstances of the case. If the court so specifies a date, there is little doubt that such date would be the date of amalgamation or the date of transfer. But where the court does not prescribe any specific date but merely sanctions the scheme presented to it, as has happened in this case, it should follow the date of amalgamation or date of transfer as the specified date in the scheme, which is nothing but the appointed date. So we'll have to wait and see if there is any more clarity which is given by the department on what will be seen as a date from which this could be seen as being affected, whether it is the date of the order or whether it is the appointed date. Another important aspect that comes here is the way 6B has been written out. It says that it gives reference to the original predecessor. It says that the deemed loss of the successor entity to be carried forward for not more than 8 assessment years after the assessment year in which the loss was first computed for the original predecessor. They use the word original predecessor. Now, there are two ways of interpreting the word original predecessor, and it has not been defined so far, not even under the finance bill. If I look at the literal interpretation, then the restriction on the carry forward of the loss should apply only to the accumulated losses of the first predecessor entity. Whereas if I look at the purposive interpretation, then it should apply on all the losses so far. So let's look at a quick example here. That we have a company A where there was a loss of 100 crore pertaining to assessment year 13-14. This loss could have been carried forward for 8 years up till assessment year 21-22. Assume that there's a merger of company A with company B in AY 1920. And this company B also had its own loss of 40. So we have a loss of 100 and we have a loss of 40, 140. Assume that there is one more merger which is happening with company B with company C, which is in assessment year 25-26. And company C has its own standalone loss of 50 crore. And then the fourth merger is happening between company C and company D. So we have to decide what will be the eligibility of company D to carry forward the losses by interpreting the word original predecessor in this case. Now, whether the restriction of the carry forward up to 8 years will apply to the accumulated loss of company A, which is only 100 crore, or will it apply to 100 crore plus 40 crore in this case? So this is the question that we have to wait and see. In my view, it should apply to all the, all the losses which gets accumulated prior to the last merger that we're talking about. And therefore, in my personal view, a purposive interpretation is more suited in this kind of scenario, but we'll have to wait and see if the government comes up with any clarification on this kind of situations. The second amendment is in terms of, deciding the taxability arising on account of transfer of securities for AIF. All this while there has been an ambiguity in terms of the characterization of income when it comes to transfer of securities by Category 1 and Category 2 AIF. Positions were taken in a divergent way. Some of the AIF were considering that income as business income, which was taxable in the hands of the company or the LLP, in whichever way that AIF was structured at the normal rate. Or if it was structured in any other legal form, then it was taxable at MMR. In the case of a capital gains, the taxability was in the hands of the unit holders on a pass-through basis. But things were not very clear and it was leading to some sort of a litigation. So it has been now clarified that any security which is held by a Category 1 or a Category 2 AIF, that will be considered as a capital asset. They have brought in by way of amending the definition of the capital asset in section 214, and accordingly, any income which arises on account of transfer from from the transfer of securities will be characterized as capital gains. Now, this position is actually consistent in terms of the earlier CBDT circulars that we have. There are actually four circulars that one can read. One is a 1989 circular. The second one came in 2007. The third one came in 2016, and there's a fourth one which came in 2016 itself in May. Now, all this while, it was made very clear that for unlisted shares, income arising on transfer of unlisted security will always be considered as a capital gain, irrespective of the period of holding. But what was important is, if there is a transfer which happens with transfer of control and management, then it may still not qualify as capital gains. Now, one thing to note here is that in the case of CAT 1 and CAT 2 AIF, also this transfer of securities could happen with or without transfer of control and management. But now, with this overarching clarification coming in, I think this ambiguity goes away, at least in the case of AIFs, and the income has to be taxed as capital gain itself. So the way it will work going forward is that it will be taxable in the hands of the unit holders. So if it is a short-term capital gain on listed equity shares, it will get taxed under 111A. If it is a long-term capital gains other than listed equity shares, it will get taxed under 112 and under 112A for the listed equity shares, and at normal tax rate for any other securities. Because it's about transfer of securities, it will cover equity instruments as well as non-equity instrument, which could be convertibles, etc. So this is going to provide a lot of tax certainty, at least to the AIF CAT 1 and CAT 2 segment, as far as the taxability on account of transfer of security is concerned. So these were some of the key amendments that have taken place in the sphere of M&A. I hand it back to the Taxmann team, just in case there are any questions, we can possibly take it up now.
Thank you, sir. Thank you so much for this insightful session. Let me check if there are some queries. Anyone, please drop your queries in the chat box. Sir, there's one query. How simplification of fast-track merger will benefit startups?
See, I think the time that overall is taken for disposal of applications at the NCLT level in itself is, quite overwhelming. So I think the way it will, positively impact the startups is that the moment it falls under a fast track scheme and things are ironed out and made more efficient the way we spoke about, that possibly can get reduced to 3 months or 6 months maximum. So the way to look at it is, it will benefit the startups maybe by reducing the timelines and maybe a little bit of lesser documentation that may be looked at by the government, specifically for startups, for them to be looking at a fast track being made more attractive to them.
Okay. Let me see. Is there any other query? Just 1 second. So there's one a general one. That is, how would you rate this proposed budget?
See, I think the budget definitely has been quite balanced. From a common man personal income tax standpoint, definitely it has been a blockbuster, right? So if I were to rate it from a corporate standpoint, maybe nothing which catches the attention for the corporate world, so maybe a 6 out of 10 on that. But when it comes to personal income tax, maybe 10 out of 10.
Okay. So there are few queries in the comment box also. Let me take this also. Will these provisions also apply to reverse mergers?
No, this will, at least 72A will not apply in the case of a reverse merger. This will generally apply in the case of reverse mergers. If it is a domestic reverse merger, then possibly yes. But if it is, when you're saying reverse merger, it could also be about a foreign company merging into an India entity, then possibly not.
Okay.
I think I can see the second question. It says any impact on carry forward of depreciation? No, the answer is no. This is only about plugging in the business losses. Uh, Under Section 72, unabsorbed depreciation can be carried forward indefinitely.
Okay. Let me check others also. Is there any query? So I think